Tractate Bava Batra, page 113. God bless you. Thank you all for coming and being here. Thank you for those who are watching us. We are so blessed not only to have viewers from different parts of the globes. We get emails and phone calls and texting from not only from the other side of the country and South America, but also from Europe, Australia, and just get another email from someone from one of those Arab countries. The fellow asked a question, since we talk in the past several days in Hilchot Yerusha, the law of inheritance. He tried to do some type of comparative religion, and he asked about the comparison between the law of the Sharia, the Islamic law when it's come to inheritance, and the Jewish law. Obviously there is a lot of similarities. A good example is in Islam, is a person that passed away. Basically the inheritance go to the son. There are some differences. For example, if it's a passed away and you have a sister and a father, so the sister get a half and the father get 1/6 in Islam. It's called Alam Tul Paris, Dwight Tul Paris, which is the whole concept of transferring an estate. In the Sharia law, it's basically up to the 1/3 for someone who's not a blood relative. But since we are here with the obviously with the Jewish law, we're going to speak about the concept of the court system, which is we explained in the past that the court has to convene only during the day, but the session can continue during the night. It makes a difference. We learn the concept of en ed na'aseh dayan, which means, in the case we're going to discuss soon, is a person that was about to die, and several people around him, and they heard all kind of statements, and they basically edim, they are the witnesses, and they can be judges according to Tosfot and others, because they are part of that moment of that testimony. The question is, if they went from the session during the day to the session of night, if they remain in the same status. The Maharal, the great rabbi of Prague, explained to us that in general the concept of edim, the witnesses, it's almost like the eyeglasses of the judges. Mishkafei hadayanim, he called it. So in a way, in the modern days police, you have scenes, and in that scenes, those who watch Law and Order, right? So someone showed me, so they bring it back, the person bring it back to the scenes and try to do some type, in Hebrew we call it shichzur, to go back and try. By us, as the Maharal explains, the witnesses, or the cross-examination between the witnesses, that's basically the foundation of the understanding the Jewish court system. Also, we're going to discuss, time allowed, the Netivot, Rabbi Hanan Wasserman and others that discuss what exactly the understanding of inheritance of a son is. Inheritance of sons by merely fact that he was born to that father. It means that he replaced the status of the mother in a case, in a sense of Yerusha, in a sense of inheritance, the whole concept of Nachalat haben min mekor ha'em. So it's like replacing of the mother. That's another phase we're going to study, time allow. But the first case which we're going to meet today is a situation that husband-wife, the wife passed away, and she does not have the inheritance of her late father who left the estate available at that time. Meaning, she passed away, let's say, for our understanding, we here talking to a secular calendar, so let's say 2016. and the husband tried to claim estate of her father, who passed away only in the March of 2017. So basically, at the time of the father passing, she, meaning the daughter, was not living. So husband basically cannot come after that estate and claim that he deserved to have the estate of the entitled of the deceased wife, since she was not alive at the time of her father passed away. So let's start with the text itself. We are 113, 15 lines from the top of the page. אמר רבי אבאו, אמר רבי יוחנן, אמר רבי ינאי, אמר רבי, ומטובה משמי דרבי יהושע בן קורחה. מניין לבעל שאינו נוטל בראוי כבמוחזק, שנאמר, דברי הימים, הושגו והוליד את יאיר, והיא לו 23 ערים בארץ הגלעד. The key idea: husband entitled to the estate of his wife as long as they are real partners at the time of her living, meaning husband cannot claim an estate for something that happened after she is no longer among the living. Rambam, Hilchot Nachalot, the first chapter, Tur, Shulchan Aruch, Ibn Ezer, Tzadik, chapter 90, said as follows: a husband who inherits from his wife inherits only the property she possessed at the time of her death, but he does not inherit property that was due to her, such as the inheritance from her father when she was no brothers. In the event she predeceased her father, as we said, that's basically the halacha, the Avnei Ezer in the Chelek Bet have a big discussion of the concept of Ra'ui. If the money that or assets that the wife hold before she passed away, you hold it in any form of Ra'ui, meaning she have, we call in Hebrew zchut mechaim, she have the right, whenever, it can be next hour, can be in 10 years from now, whatever it is. So when it's come to Hilchot Alva'a, Malveh, lending money, Schar Peula, Gneiva, Nezikin, anything like that, that she did not have a time to collect before she died, but it's something that she entitled, you mean to say that since she is deceased, the husband cannot collect it, or you talk only inheritance that happened much later when a father passed away? So the bottom line is, from this pasuk in the in our Gemara, הושגו והוליד את יאיר והיא לו 23 ערים בארץ הגלעד, so we derive from that that basically applies solely and only at the time that she is alive. The moment she passed, then in a way the husband not only lost his wife, he lost the right to possess something that she collected afterward. And again, it's a big discussion. The Ktsot Achor, Netivot, Rabbi Yochanan Wasserman, many others discuss if it was already part of her collection, collecting rent, collecting money that was stolen from her, collecting a certain type of debt. So the key idea is, up to the moment of her passing, it's a one category. The moment she's no longer among the living, so far the husband cannot collect that. מניין לעיר שלא היה לסגוב, אלא שנשא סגוב אישה ומתה בחיי מורישיה, ומתה מורישיה וירשע העיר, ואומר אלעזר בן אהרון מת ויקברו אותו. מניין לפנחס שלא היה לו אלעזר, מניין שנשא אלעזר אישה ומתה בחיי מורישיה, ומורישיה וירשע פנחס. So the key idea is, we learn from this biblical text that the husband cannot collect fund after her passing the way that he collected until she died. בראוי כבמוחזק. What is befitting in one stage when she was alive versus when she's gone. ומאי ואומר, what is the addition of the statement? Why is necessary to provide an additional proof beyond the first pasuk? So the Gemara explained, וכיתה מדע ונסיב איתתה ומתה וירתה, which means in this case of Yair, he married a wife, a woman, and then so it means that she died. Talmud lomar ולעזר בן אהרון מת. וכיתה דנפלה לבזדי חרמים. So it means because he was a Kohen, so that was part of the property, that Piנחas inherited the land of whose before whom his mother inherited, and Elazar did not. אמר קרא בנו, נחלה ראויה לו וירשה בנו. So again, the husband cannot collect a fund after her passing as he used to before. Then the Mishnah said, ובני אחות. So sons of sisters, which is nephews born to the sister of the deceased, inherit from the maternal uncles, but not bequeathed to them. Tana bnei achot, velo bnot achot. Page 113b. Lemay hilcheta. What's the reason of this point? It's obvious that the daughters have the right to inherit from the maternal uncle as the mother inherit from him. Amar Rav Sheshet lekadem, to precede the daughters inheriting from the maternal uncle. תנא רב שמואל ברב יצחק קמי דרב הונא וירש מקיש ירושה שנייה לירושה ראשונה. מה ירושה ראשונה בן קודם לבת, אף ירושה שנייה בן קודם לבת. So in general, as we see, when it's come to inheritance by the structure of Jewish law, son take precedent before daughter. Obviously, we are not yet in a practical stage of what we are doing today, but the structure is son is the son, daughter in that structure marry out of family, move out of family, etc. Obviously, we're going to revisit this subject later, but let's first continue with the general choshen mishpat, the general mindset. Tana Rabbi Chanina Kamei דרב נחמן, והיה ביום הנחלות בניו, ביום אתה מפין נחלות ואתה מפין נחלות בלילה. The key structure is that the court convene during the day but not night. We derive it from the pasuk in Deuteronomy 21. They say, then it shall be on the way that he causes his sons to inherit it. So since you use the term on the day, so on the day we derive specifically that the court convene during the day. You don't distribute inheritance at night. אמר לאביי למעתה דשכיב עמה והוא דיארתה לבני, דשכיב בלילה לא יארתה לבני. You mean to say that someone who passed away at night, the children doesn't have a Yerusha just because he died at night? So obviously it's impossible. דילמה דין נחלות כאמר. תתניא והייתה לבני ישראל חוקת משפט, או כל הפרשה כולה להיות דין. וכדי רב יהודה, אמר רב יהודה, שלושה שנכנסו לבקר את החולה, רצו כותבים, רצו עושים דין. So in general the idea is, we talk about structure of inheritance, which is the court has to convene during the day. Now, therefore, you have to have a court of 3 judges, and you have to have them convene during the day. Now, the derivative is, imagine a situation, 3 people came to visit a person who was very ill, and he informed them how he wants to divide his estate. And then they asked to write some promissory note or some document that go and follow his wishes, Rashbam explained, and then the heir bringing that shtar, that document to the Bet Din. So the idea is Ratzu Osin Din, so it means, and here is a very painful and heavy disputation between Rashbam and Tosfot. What's the idea? The idea is, Rashbam said that when you're dividing a state, Chalukat Nachalot, you have to have a decorum of Bet Din of 3 judges. Otherwise, there's no tokef. Otherwise, it's not effective rules. You have to have the judges convinced, and there have to be 3. Tosfot tried to say that if a person convinced 3 people, and they are there at the time of the passing, they can be a judge. They have the tokef, the gushpanka, the capability to be a judge. Now, the big question, the challenge between Tosfot and Rashbam, we know the rules that en ed naasa dayan, that a witness cannot turn to be a judge. How you do that? Furthermore, the whole concept of olchin achar hanitba, which is a big controversial concept, is the Rema and others, that you have Reuven suing Shimon, and Shimon said, I don't want you to sue me in your city, you have to come to the place I live, because you go by the defender, not by the claimant. Now the truth is, in the Choshen Mishpat there is a follow-up this discussion of the Rashbam and Tosfot. The notion is the witness cannot be a judge, because if you go by the pasuk which we just mentioned and the derivative, the Torah said ve'amdu shnei ha'edim b'fnei Hashem, the 2 witnesses need to stand before God. So the Gemara derived from that that's not the claimant, lo hatovea ve'hanitba. It's not the claimant and the defender, but it's applied to the 2 witnesses. The 2 witnesses, they need to stand before the Almighty, Elokim nitzav b'dat kel, and before the judges. So that's basically, you go by as follows: the Choshen Mishpat, you have tovea and nitba, you have the claimant and the defender, you have the proof, which is come toward the eidim, toward the witnesses, and then you have marechet shfita, you have the people who judge, which are the dayanim. So since the whole discussion is go further with the idea of what does that mean, ve'amdu, they should stand. Can you bring a witness on a wheelchair or not? It's a disputation. You go by the Shulchan Aruch, by the code, lo me'akev. It's not the issue. You go by the others, they said it is me'akev. But anyway, here we said, שניים כותבים ונושאים דין. ואמר רב חיסדא לא שנו אלא ביום. Rav Chisda said that all of this, the halacha was taught only in a case where the 3 came to visit him during the day. Page 114. אבל בלילה, but if they came at night, so he said, אפילו 3 כותבים ונושאים דין, even if the 3 men came to visit the sick person, they may write the will and signed it as a witness. מהי דאבו ליודעין, ואין עד נעשה דיין. As we said, that the witness cannot become a judge, which means one who acts as a witness in a particular matter cannot become a judge with regard to the same matter. So he responded, said, Amar lei, Rabba Bar Chanina responded to Abaye, and he said, Ein hachename ka'amina. This is my intent. And he said that that's exactly what I'm saying. Now, the truth is, there is a big discussion halacha, such as the Nimukei Yosef, the Turei Even on Rosh Hashanah. What's the idea of en ed na'asa dayan davka bayom? What does that mean when you talk about the witnesses that come and give a testimony during the day, especially if they can turn around and the court continue to have a discussion and it's already dark? How you exactly treated, and when exactly and where you can change the status from ed to dayan and when not, and how the structure of that applies. So as we said, we just give you the vignette. You want to read more, you have number 1, Ktsot HaChoshen chapter 7 is dealing with the concept of Kabbala Tedut Balayla, accepting a judgment at night. You see more in the Shulchan Aruch Choshen Mishpat in chapter 5. He said, if 2 men visited a sick person and he declared before them how he wished to bequeath his property, they may write his will, but they cannot adjudicate the matter. If there were 3 visitors and the sick person stated an irrevocable declaration of his will, then they may either write his will as witnesses or adjudicate the matter. meaning that they have the authority to distribute the property to each heir according to his position and rule concerning any uncertainties that arise with regard to the condition of the will. None of the heirs can contest the authority and insist on transferring the case to the jurisdiction of another court. This halacha, you see more in the Rashbam in Chod Sanhedrin chapter 3, applies when the sick person stated his will during the day. But if he did so at night, the visitors are authorized only to write the will, but not to act as judges, as judicial deliberation cannot take place at night. The Ramah writes that if they did adjudicate at night, their judgments stand, but the Shach disputed the Ramah and totally disagree with him. So as you see, between the Ramah, the Shulchan Aruch, the Rashbam, the Rosh, and much more, the Tosfot Rosh Hashanah 25, you see more in Turei Even on Rosh Hashanah, you see that Tosfot Rabbi Akiva Igi Rosh Hashanah 3, you see that Dimukei Yosef, you see a huge discussion how far you go with witnesses, if witnesses can be judges, if witnesses can do any form of continuing testimony at night, and hopefully we'll revisit this subject soon.